There is a trending issue between Doris Ogala and Pastor Chris Okafor, where Doris Ogala came out and told the world that she intends to sue Pastor Chris Okafor for breach of promise to marry. She claims that she has all the evidence and that her lawyers are preparing her claim so that they can file a civil suit against the pastor. Now, what does the law says about breach of marriage? And also, does Pastor Chris likely have a defense? Just quickly look at the law and see what the law has to say about this. But before I continue, please like this video, share to your friends, and also subscribe to this channel so that you can get more legal tips like this. So what does the law say about breach of promise to marry? Now, for you to succeed in a claim for breach of promise to marry, now the law treats the promise to marry as a contract. So number one, there must be a valid offer. The valid offer is probably, it may be written, it may be implied, probably a proposal. Maybe he nails down, the popular way, and he proposed to you, will you marry me? There must be a valid offer. Now, after you prove that there was indeed an offer to marry you, you must also show the court that you accepted that offer. It's very important to show the court that you accepted that offer, because you see, the court is not just going to listen to the romantic talk that you had between both of you. Maybe he was very close to you, he was telling you things at the night, calling you at the night. No, the law is not concerned with those emotional things. What the law is looking at is the intentions of the parties. Now, so after you accept, the court is also going to check, was any consideration furnished? So the court will also check, did the parties intend to make this thing legal? So that intention is also very important. Is it just one of those jokes that people are making, or indeed? So you have to prove that indeed, no, both of you intend to get married and you intend to make this thing legal. So you also have to show the court that you have suffered damages as a result of that promise. In other words, you acted on the promise. Maybe both of you are planning, the wedding already. You've paid for an event center. You've contracted tailors. You've paid people to, cook already. You have to show these things. So it's not as of right. It's not just because a guy walks up to you or a lady walks up to you and they promise you marriage, then you now think that you have a claim against the court. No. But we say once you have all these things, definitely you have a case and you can approach the court just the way she's about to approach the court. Court is going to weigh the evidence to truly ascertain if indeed there was a breach of promise to marry. And also, the person who breaches, are there defenses that can protect the person? There are many defenses that that can be used. Number one, you can plead duress, you can plead misrepresentation. Depending on the fact and the reason for the breach, the person can also explain to the court, and if the court sees it as a legal remedy, indeed the court will dismiss the suit. However, if the court sees the defense as just a flimsy excuse and all that, the court will ensure that the other party is duly compensated in damages. Now note, you cannot ask for specific performance. The court cannot impose an unwilling man or unwilling woman on the other partner. If the other person is not ready to get married to the other person willingly, the court cannot impose. Did you gain value from this video? Please share with me at the comment section. I would love to hear from you, and don't forget to subscribe and follow this channel. Thank you.